Good evening once again to all of you. So those of you who were able to join us afternoon or the early version, what we thought to do was to go back to 2019 question paper and use the questions there to provide some prompting or to trigger discussion around the very issues emanating from the questions and also the various options there. And as we keep emphasizing, it's not so much about we providing answers to questions, but more importantly, about explaining and clearing doubts or deepening your understanding of the issues around the past. In any case, these are the matters which fall within the examinable areas. And even if the same questions are not being, the matters we are discussing are some of the things which will come in the question in some other way. So if we have a better understanding of them, I think that we are not wasting time. Okay, so in the context of that understanding, I will continue with the discussion of the 2019 question. So in the afternoon, we did the first and then the 5, and we avoided one, saying that it was part of commercial law. The law. We look at the 6 examinable areas. The law of agency is not, the commercial law in general is not one of those examinable areas. So we decided to take that out. So let me switch off my listing. Yeah, so question 6. The doctrine of privity of contract is that a contract cannot confer rights or impose obligations arising under it on any person except the parties to it. In respect of a lease, which of the following best describe the said doctrine? Okay, so this is a very interesting question, raising a very interesting issue. So first of all, we know privity of contract. Privity of contract, just a quick recap. We know that in the case of Tweddle and Atkinson, the position of the law was that a contract created no right or obligation for third parties. And for that matter, later on in the case of a Dunlop against Enigmatic Tide, the court will say that under English law, there's no concept known as a quotiatum tertio, that a contract does not create a benefits or obligation for third party. However, later on, we saw how the court said that, well, despite the fact that it may be a third party, there are some other ways in which you may be able to enjoy under a contract to which you are, so to speak. So you see how in like Viscount Haldane, in Dunlop against Dunlop and Suffrage, for example, mentioned that maybe trust, agency, assignment, and all that. These are some of the ways, and of course, restrictive covenants, the rule in the talk of Moshe. And in more recent times, statutory exception, especially in Ghana, our section 5 of the Contract Act 1960 Act 25, the position of the law is that where a contract has created a benefit for you, despite the fact that you are a stranger, you will be able to enforce that contract. Or if you belong to a class of a designated, class of designated beneficiaries, by reason of your membership of that class, you'll be able to also enforce that contract. So in a nutshell, that is the position of the law concerning privity in general. Then we also have a privity applied to land law. Don't forget that when you talk about like a lease is a contract fundamentally. is a contract relating to land, creating a specific quantum of interest in terms of like the duration for which a person can enjoy a certain parcel of land and all that. So that is what a lease is. And for that matter, fundamentally, it is contractual. If it is contractual, then it stands to reason that most of the things that we know, even in general contract, are applicable to lease, mutatis mutandis, or with the necessary modification, as the case may be. For that matter, let us look, so that if there's a lease, right, there's a lease between a lessor and then a lessee. If you are a third party to the lease, in the sense that you are not a lessee, how can you benefit, or how can you enjoy, or how can you have an obligation under it? Now, a number of scenarios. If, for example, A is a lessor, B is a lessee, and A has given B 50-year leasehold. That is, B is supposed to have exclusive possession of the particular Blackberry or particular land for 50 years. Now, what that means is that with consent of A, B as a lessee can also carve out some of his interest to other parties. So B can, for example, get consent of A, the lessor under the head lease, and also create what we call like the sublease. So B can create sublease, maybe 30 years for C, so that if you take the 30 years out of the 50, it's still left with the what we call the 20 years, and he can still be creating. C can also create a sublease that way. Or another way is that with the consent of even like the A, B as a lessee can decide to transfer the entirety of his interest, the quantum of interest that he has. That is the 50-year lease. He decide to transfer everything. And when he does so, we say that he has done assignment, right? So that B becomes the assignor and C becomes the assignee. And for that matter, C will assume the position of B, and B will drop out of the picture. And what that means practically is that the original lease between A and B, in terms of the rights and obligations created under it, will now apply to C, who is the assignee in terms of the assignment between B and C, so that C will assume the position of B, and whatever A could do under the head lease against B, he'll be able to do it against C, despite the fact that C was originally a stranger or not a party to the lease. And of course, whatever B could also enjoy can now be enjoyed by C, despite the fact that he was originally not a party to the lease. So with this understanding, we proceed to look at the question once again. The doctrine of privity of contract is that a contract cannot confer rights or impose obligation arising under it on any person, except the parties to it. In respect of a lease, which of the following best describe the said doctrine? Okay, I would like to take your answers before we work ourselves through the options to arrive at the correct answer. So if you want to try, you can put your answer in the chat. Okay, we have a one trier, one Emmanuel Zaika. Yes. Is he the only one who can answer that question? Or who cannot answer, who can attempt it? Let's put it that way. Attempt it. Use the chat to attempt it. Okay, another attempt. Another attempt. Another attempt. I hope you are not just casting the vote, because someone has voted You're also voting in that way, but you are convinced by your own choice. Okay. I will come to those of you who have selected B. Your answer before we go through the options. So I want one lady and one gentleman to explain why you opted for B as the correct answer. You can put up your hand and then I will release you to talk. A number of you said B, so you should be able to. And that is why I keep telling you that I'm not just interested in the answer. If it was just the answer, you could just send the answers to you and then you go through the question, but that was not important to me. What is important to me is for you to understand the surrounding context or the topic. Okay, FJA, you can talk.
Okay, so good evening.
Good evening.
Yeah, I chose B because the relationship should exist between the three of them. So that if it's anything that the Lisi enjoys, that assignee to enjoy, and any covenant the Lisi suffers, the assignee to suffer the same thing, which is created by the Lisor. That's why I went for the B. Thank you.
All right. Thank you, Lady FJ. Then so far, she's the only person who has been able to explain her choice. The rest, we just did what in the primary school we call chusubidie, meaning that you just chose without being able to justify your option. Okay, so now let's go through the answers to see whether Lady FJ is correct in the choice of B. Okay, Barrister, I want to have a class review. I want to have a bite at the cherry. Okay, go ahead.
Okay, I also went for B because applying your elimination method, when I peruse the other options, and per my understanding of privity or contract, I think in any case, it's like three parties to one contract in some sense, three parties, the original two parties, and then the third party. So it appears like the answer must contain or should contain three parties. So when I read option A, relationship exists between the lessor and lessee and between them only. So with my elimination method and my understanding of privity or contract, I noticed that it cannot be between them only. If that is just between the two of them only, then that is not privity. We are not talking about privity. And I also took B, the relationship which exists between the lessor, the lessee, and assignee from the lessee of the residue. So that one contains some three parties. So that is giving me a clue that with the knowledge of privity or contract, it sounds better. So I leave it there and I took option C to the relationship which exists between a lessee and an assignee or the reversion, which also has only two parties there. So that cannot be said to be talking about maybe privity or contract. A third party ought to have been mentioned. And then I think the same thing for D2. So I did that analysis and I was satisfied that B should be the answer. Thank you.
All right, thank you very much, Barrister. So we all discuss together for the last time and then we move on. Saint Mugai, you have the chance when we move on to question, the next question. Yeah, so he's done some analysis, so let us revisit that together. Relationship which exists between the lessor and the lessee and between them only. So if you are to take privity of contract as espoused in Tweddle and Atkinson, Dunlop and Separate, if we are to bring that analogy to the context of a list, then one will argue that A is a promising candidate, but we haven't settled on A yet as whether it's the correct answer or not. Because like the relation between the lessor and the lessee is just like the relationship between like the original parties to the contract. Just like the, if you like, situation, the Tweddle and Atkinson and so on and so forth. Now let's go on to B. The relation which exists between the lessor, the lessee, and assignee from the lessee of the residue of the term. And now let's wait a minute. What is the original lease, the original contract between the lessor and the lessee, right? And technically, the assignee is, if you like, a stranger to that, unless the assignment has taken place with the consent and all that. And he's talking about the assignee of the residue of the term. That is the unexpired term of what the lessee have under the lease. So let's say that the 50 years lease, right? So let's say that the lessee has been on the land for about 10 years. It's left with 40 years. So if there's an assignment, the residue is the 40 years. And that is what will go to the assignee. And then the lessee is like the assignor. And the assignee will assume the position of the lessee. But if we are going by the understanding of privity, does B actually illustrates that? The original contract is between lessor and lessee. And can it create obligation for, if I let somebody switch off the water pump, it's overflowing. Okay. Can it create obligation for the assignee who's like a third party? So let's flag B. We haven't settled on B yet. C, the relationship which exists between a lessee and assignee of the reversion. And when we talk about like the reversion, right? Reversion refers to the, if you take like the head list, let's say the example that I gave, 50 years. After the expiry of the 50 years, the subject land or the subject property will go back to the lessor. So the interest or the property going back to the lessor after the expiry of the quantum of the lease, so in this case, after the expiry of the 50 years, is what you call like the reversion. So if you take that, the reversion actually goes back to the lessor, not the lessee. The lessee has nothing to do with the reversion. The lessee has nothing to do with the reversion. And assignee is in the same possession as the lessee, as far as the reversion is concerned. And for that matter, C is out. C is no. The relationship which exists between an assignee of the reversion and the C said that the relationship which exists between the lessee and assignee of the reversion. Of course, the assignee of the reversion can be no other person. If we are speaking in respect of like the head list, right? You are speaking in respect of like the head list, then the reversion will go back to the lessor. So it's just the lessor who is assigning his reversionary interest to another person, in which case that person is the assignee of that reversion. Or if you are speaking in respect of, let's say, like the lessee having like the lease and he creating like a sublease, right? So he has like the 50 years lease and he has created a sublease of 40 years, meaning that after expiry of 40 years, you still have 10 years remaining. And 10 years is the reversionary interest under that sublease which he has created. because after the 40 years, the lease has not expired. The lease has still got the so 10 years to go. So in respect of that, there's also a reversionary there. And then we have like the reversionary interest under the head lease. That is after the expiry of the 50 years, the land will go back to the lessor. So we have to put it in context. If we talk about assignments of the, let's say, if you talk about the assignment of the reversionary interest under the head lease, then certainly that has got nothing to do with the lessee, unless maybe like the lessor is just giving everything back to the lessee, but that is not, because in that case you have what they call like the merger. You have like the principle of like the merger kicking in. So let's go on to D, the relationship which exists between an assignee of the reversion and assignee of the residue of the term. Okay, that is interesting. Now, assignee of the reversion, using my 50-year example, right? Using my 50-year example, you have a leasehold of 50 years. After the expiry of the 50 years, the property will go back to the one who created the lease, that is the lessor. So that is a reversion. Now, it is permissible for the lessor under the head lease to enter into an arrangement and say that I am transferring my reversionary interest. That is my right to have the property returned to me, reverted to me after the expiry of the lease hold or the duration of the lease. I'm transferring that to, let's say, C. Now, if I transfer that to C, we say that I have done assignment of the reversionary interest. You've transferred that. Okay. So that is the assignee of the reversion. So that is how it comes about. And then let's talk about the assignee of the residue of the term. Assignee of the residue of the term will apply to the lessee having been given 50 years and maybe having spent 10 years, is left with 40 years. So the 40 years is the residue of the term of the lease. And he can decide to assign that. Assign that means that he's transferring the entire remaining 40 years to C. Now, if he was just, for example, giving part of the 40 years to C, then that will be a sublease. So get the difference. If he's just giving part of the remaining to, let's say, C, that will be a sublease. But if he's doing assignment, then he's transferring the unexpired residue. So in this case, the example that I've been using, if it's been there for 10 years and it's 50 years, it's 40 years, which he is taking. So in the light of what I have said, which of these three scenarios brings out privity in the context of a lease? You have to reconsider some of the answers that we give. Some have said, let's say that some have said A. Okay, now we have people A, B, D. But nobody, okay. We have the answers, let me see. Barrister, you're throwing the towel, don't throw in the towel. Okay, yeah, so in the light of what we have discussed, it was very interesting. Some of you are just trying to force to see three things there before you think that the right answer is there. Now, the relationship between the lessor and the lessee, it exists between only them. Is that not the case? Unless there has been a valid assignment. Unless there has been a valid assignment, the obligations that the lessee has under the lease cannot apply to any third party. Neither can the right which the lessee has under the lease can also not be enjoyed by any third party. And is that not a description of the original idea of privity? Is that not the idea we see under Tweddle and Atkinson and Dunlop and all that? It's the same thing, because it said that if you are not a party to a contract, it does not create a right or obligation for you. Yes, and if that is so, why will you ignore A as the correct answer and go on to B? Because if you take like the B, right? If you take the B, let's test correctness of A against all the rest. Administrator, you want to say something? Okay, go ahead. Yes, go ahead. Administrator, you can mute yourself.
Doc.
Yes.
I'm of the view that looking at question 6, say the doctrine of privity of contract is that a contract cannot confer rights or impose obligations arising under it on any person except the parties. So your answer A is correct, because it's a negation of whatever is captured under section 5 of the Contract Act and what you have explained. So we have to also take note of certain words when the questions are framed.
Yeah, that is true. And section 5 is an exception. The section 5 says that despite the fact that you're a stranger, the contract can create a benefit for you and you can enforce it. So that is creating a direct exception to the original doctrine or the original principle of privity of contract. Exactly. So we're trying to test correctness of A against the rest. So let's say like the B, the relationship which exists between the lessor, the lessee, and assignee from the lessee of the residue of the term. Now, if you take that, you rather have an exception, because as soon as you have like the assignee there, it means an assignment, and we know that even before we come to have the statutory exception per section 5, if you read Viscount Halden's decision in the Dunlop and Pneumatic Tie, he makes the point that the only way by which a contract can create a benefit for someone by the quotientum tertio is, for example, such as by an assignment or trust or anything like that. So therefore, an assignment becomes an exception to the principle. And that is why B cannot be the answer. Because once you have assignment there, then it's making it possible for a contract to create a right or impose obligation on a third party. And as we explained, once assignment takes place, let's say the lessee will have transferred his entire rights and obligation under the head list to C, the assignee. And for that matter, despite the fact that the assignee, C, was a stranger to the original list between the lessor and the lessee, will be able to enforce it. So B is out. Now let's go to C. The relation which exists between a lessee and assignee. So you are still seeing the assignee. So if you understand it, as soon as you see assignment there, you have to know that assignment is an exception to the principle. And certainly, the principle is being stated in its pristine form or in its orthodox formulation without the exception. And that being the case, A will be the most suitable answer. Who is confused before we move on? But say sounds is a little bit technical. Who is confused before we move on that we explain? You know, there is another principle. Let me just code this thing. Yeah, anybody? If you are just feel free. That's why we are here. If you are not clear, then we explain it. Because once you come, when we move, my assumption is that all that you are doing, all of you understand. And for that matter, if you are to get anything around what they're talking about in the exam, you should be able to do it and pass. That is the idea. So if you don't understand, you have to let us know. Good. We also have a related concept, right? Apart from privity of contracts. Apart from privity of contracts, we also have a related concept we call the privity of estate. Privity of estate. So if you look at the Black's Law Dictionary, have the 11th edition at home now, page 1453. A mutual or successive relationship of the same right in property as between grantor and grantee, or landlord and tenant, also termed privity of title or privity in estate. Yeah, so just the yes. Administrator, what is it? Okay, so we move on. So let's go on to another area. That is question number 7 of the 2019 paper. In your view, and as I keep telling you, I'm not telling you that, I'm not saying that they're necessarily going to repeat 2019 paper. No, I am revising generally with you, and the question provide, if you like, some prompters for something, for us to talk about something. That is the idea. Question 7 of 2019. In your view, which of the following will not justify the use of force or infliction of harm in our criminal justice system? The use of force or infliction of harm in our criminal justice system. So if you get something like this, your mind must go to the Constitution and also to Act 29, the Criminal Offences Act. The mind is a bit far away. And your mind should also go to the Constitution. So in what respect is the Constitution relevant in talking about permissible use of force and infliction of harm? Before we come to Act 29, can anybody explain? Yes, can anybody explain? Okay, the person who put down the session, you're not being interactive. When I ask a question, just make effort and then say something. It doesn't matter. If it's wrong, you have no trouble with anybody. If it is correct, that is fine. So we are talking about use of force, and we want to look at the circumstances in which the law will justify or permit the use of force in our criminal justice system. And I mentioned the fact that we must have regard to the Constitution, and you must also have regard to the Criminal Offences Act. And I want somebody to explain. Yes, Jos. Jos, yes.
Hello, sir.
Yes.
Okay, so this is in Article 13, Clause 2. So if I may read Article 13,
yes.
Clause 2.
Yes.
It says that a person shall not be held to have deprived another person of his life in contravention of Clause 1 of this article, if that person dies as a result of a lawful act of war, or if that other person dies as a result of the use of force to such an extent as is reasonably justified in the particular circumstances. A. For the defense of any person from violence or for the defense of property. Or B. In order to effect a lawful arrest or to prevent the escape.
Yes, go ahead. Are you there?
Yes, can you hear me, sir?
Yeah, we can hear you. Yes, you went off a little bit. We can hear you now.
Okay. Or C. For the purpose of suppressing a riot, insurrection, or mutiny.
Okay. Are you done? Are you done? I don't have my constitution with me. Have you finished?
Or D. In order to prevent the can you hear me?
Yes, I can hear you.
Yes. So looking at the possible answers, I think it is C that resonates well with me.
Okay, I think you've rushed to the answers, but good. But I was interested in you telling us the general position of the law first, as you have done, and then somebody also mentioned section. Somebody mentioned section 31 of the Criminal Offences Act. Another person 30 to 45. So can you take the Act 29 and read section 30 to 45 for us, as it were? The person who did, yes. If you have your Act 29 with you, I don't have mine readily with me. Yes, Administrator.
Section 31.
Okay.
Grounds on which force or harm is justified. Force may be justified in the case and in the manner and subject to the conditions provided for this chapter on the grounds A, of express authority given by an enactment, B, of authority to execute the lawful sentence or order of a court, or C, of the authority of an officer to keep peace, or of a court to preserve order, or D, of an authority to arrest and detain for felony, or E, of an authority to arrest, detain, or search a person otherwise than for a felony, or F, a necessity for the prevention of or defense against a criminal offense, G, of a necessity for defense of property or possession, or for overcoming the obstruction to the exercise of lawful right, H, of a necessity for preserving order on board a vessel, or I, of an authority to correct a child, servant, or other similar person for misconduct, or J, of the consent of the person against whom the force is used.
Yeah, okay, thank you. So now it's thank you very much. It's obvious for us going through the list. And again, if we didn't know, right? If we didn't know, let's suppose that yes, Administrator, your hand is up. Okay, all right. Let's suppose that we've not read these provisions of the, I think the 31 of the Criminal Offences Act 29, or you don't remember this provision of the Constitution, which Jules read, that is it 14? No, was it 13 or 14? Which provision did you read? Okay, Saint Muga, you want to say something? All right. Yes.
No, he read Article 13 too.
Oh, all right, 13. All right, thank you. So let's suppose that, let's assume that you don't know these provisions, but you still need to work out and get the right answer. some of the things, if you look at them closely, you can use common sense to get the correct answer. The question is asking us to point out the instances in which use of force is not permitted in our criminal justice system. Let's run through. A, necessity for prevention of or defense against a criminal offense. I mean, that is quite obvious for us. So that is permitted. B, necessity of defending property or possession, overcoming obstruction to the exercise of lawful rights. That is also permitted. C, necessity of a person engaged in a brawl to defeat his adversary in the brawl. It's like a fight. A brawl is like a fight. You are fighting, and you have to use force to defeat your opponent. That is not permissible use of force. If you are using force to defend yourself against your opponent, then that one is a different matter. But that is not what C is talking about. In any case, if you take A has already taken care of self-defense and all that, so that will not even come up again as far as C is concerned. Then D, necessity for preserving order on board the vessel. Yeah, so ensuring peace. And that is a common sense to tell us that that is something legitimate. So you could use elimination to arrive at C as the answer. Yes, and Muga, your hand is up.
Yeah. So the so listed, are they for private citizens or for peace officers?
Okay, it's talking about the criminal justice system and the use of force. If you look at was it Article 13, right? Article 13 that you read, as well as Section 30. Use of force is use of force. It doesn't, because like, if you have to, let's say that somebody is going to burn, like another person's property, right? Is going to burn another person's property or is going to do something. Let's say that you have a hint that somebody is going to throw a bomb in a crowded place. If you are strong and you can restrain the person, and the person is able to create that havoc, yes, you have prevented the commission of offense. You don't need to be a police officer. You don't need to be a peace officer. The defense will avail you so long as it can be demonstrated, except that you are taking like a risk, isn't it? Yeah, and then like, yeah, so and also defending property. So someone is coming to pull down your house and you are strong, you can use something to overpower him so that it doesn't pull down your house. If you can get evidence to actually show that this is what you was coming to do and all that, and you use force to prevent that from happening, I think that you can take advantage of what the constitutional provision is saying, as well as the Criminal Offences Act. Yeah, that's my view. I don't know if any other person who's like a different view. Okay, otherwise, let's move on. Main profits. Although some when we were law students some years ago in Legon, how to pronounce this was difficult for us. So we used to call it the Mancini profits. But later on, we got to know that it was the main profit, and the S is the S is silent, as it were. Good. So I will start from the definition of it in the Black's Law Dictionary. As I said, when you are learning, you have it by your side. It's quite handy instead of all the time. For example, going to look at Megary and Wade, or going to look at the Nice's book or Lodo's book to know what it means. If you, for example, you are your law dictionary, you have like the meaning. So if you go to the 11th edition of the Black's Laws edition, page 1186, mean, they've even provided the pronunciation there for us. The pronunciation is provided M-E-E-N, so that's how it's pronounced. So that's why I say like mean. So you don't say, Saint Guy, please mute yourself.
Hello.
Mute yourself, administrator. If you want to speak, raise up your hand and then I will mention your name and then you speak. Okay. So the means profit, if you look at the Black's Law dictionaries I was doing, this is what is provided there, quote, occupying a middle position, intermediate or intervening, especially in time of, no, I mean, that is just like the mean, but we're interested in like the mean profit. But just simply put, if you have a tenant who is, for example, his tenancy has expired, is in the occupation, is a statutory tenant and all that, he is not paying the original rent, but so long as he's in the possession, he has to pay a rent, and that is another example of like the mean profit. But I want to quote exactly what is stated under mean profit, and so action for mean profit. Okay, let me look at it. I'll be under profits. Okay, so profits, that is a page 14, page 1463 of the 11th edition of the Black's Law Dictionary. Profits is defined, mean profit defined as follows, quote, the profit of an estate received by a tenant in wrongful possession between two dates, also termed the medium tempus. So the profits of an estate received by a tenant in wrongful possession between two dates. That's like the main profits. So let's go through the options to determine the correct one. The average of profit made from management of a landed property over a given period. Not necessarily. So let's move on. Profits existing for the benefit of the owner of the dominant tenement and exercisable only to the extent to which the dominant tenement can benefit. That is also not necessarily, because by this dominant tenement idea is taking us into the era of what do you call it, the easement, right? Easement, and then like the profit, like the apron. And so that's why it's taking us, but it's got nothing really to do with that. C, profits made from management of an estate, which have not yet been paid to the estate owner and are being held in the meantime by the estate manager. Let's not really, but let's flag that. Let's flag that because that is a bit closer to what we have said the mean profit is. D, rents or profits which a person with no title to the land he has entered into receives or makes, or which he might have received or made from the land during his occupation. Good. So D is the correct answer. Because if you remember, we explained that the mean profit from the definition that I quoted for you, that the profits of an estate received by a tenant in wrongful possession between two dates. So you have someone who is in a wrongful possession. That is why I also even mentioned like the example of like, let's say like the statutory tenant. Remember statutory tenant from your landlord and tenant law. Statutory tenant, someone whose tenancy has come to an end, or who under the tenancy he's not supposed to be in possession, but the law is saying that he should remain in possession until he has been ordered to evict or to yield possession by the court, as it were. So he becomes a statutory tenant, and you have to pay rent, and part of the rent that to pay is like the main profit. Or let's suppose that you have like a trespasser, right? You have a trespasser or a squatter who has been occupying a property. If you succeed in getting declaration of title and so on and so forth, you could also ask for mean profit, because he's occupied like the property and he ought to have paid something for it. So D is the most correct answer. Now, I'm going into the area of like the thoughts. Section 15 of Civil Liability Act 1963 at 176 defines dependents in relation to a person whose death is caused by a wrongful act as one of the following. Now, this is the type of question, and that is why yesterday, when we were discussing land law, I spent almost 40 minutes or 30 minutes going through this section 281, that is the interpretation session we do, because certain terms there are being defined, and it is the meaning over there which is required as far as those words or phrases or expressions are concerned, and not anything outside that. The same thing applies to the Civil Liability Act. If you go to the Civil Liability Act, it defines dependent. It is something that you either know or you don't know, so to speak. And that is why we need to look at some of those legislation and pay attention to certain words and how they are defined, or how the lawmaker wants us to understand them. So if we take I'm just able to open my act thanks to internet now. Just by having your phone, you can have almost all the laws at a click, which is good. Good. So if you look at the Civil Liability Act, if you go to section 4, it is headed definitions, right? So let's definitions. Sorry. No, I know. I think we have to go to section 35. Okay. If you go to section 35, it defines certain words, but interestingly, dependent is not explained in the interpretation session. So what it means is that we have to go through the act itself, and then in the act itself, that is where we will get the definition of the defendant. So let's start from section 22 and 21. 22, a cause of action vested. I mean, just for the sake of those who are not familiar with the Civil Liability Act, it's a very important legislation, and among other things, it addresses the issue of survivor of causes of action, right? When we say survivor of causes of action, in the past, there used to be the principle that a personal action died with a person. But then the lawmaker intervened and said that in some cases, a personal action does not have to die with the person, and the action can survive. In other words, the person who is entitled to have sued, right, to get compensation or damage or whatever, that's why the fact that he is dead, his estate, those who are supposed to benefit from his estate, can still go to court and ask for things which he could have obtained were he to be alive and things like that. So we call that the survival of cause of action. And that is why the Civil Liability Act is very important. So if you look at section 22, Emmanuel Zaika, Emmanuel, your hand is up.
Doc, I was thinking that because in the question it makes reference to section 15. Once you open the act, we just go straight to section 15.
Oh, right. Okay, sure. Yeah, right. That's true. But I was just also just saying some other general commentary that in case you are not very familiar with the Civil Liability Act, among other things, it addresses what we call the survival of causes of action. What it simply means is that if a person dies, the cause of action he was entitled to does not die with him. So if you look at section 22, for example, a cause of action vested in a person shall, on death, survive for the benefit of the estate of that person. And what that simply means is that if at the time of death, you hadn't known for the fact that you are dead and you are alive, you could have, for example, gone to court and recover certain things and all that, then that will be considered as being part of your estate. And those who are entitled to benefit from your estate can go after that. So let's go to section 15, the definitions. The problem with the Civil Liability Act, let me say that legislation is that there are drafting infelicities. Drafting infelicities in the sense that it's not neat. Look at it. We have a number. We have like section 4, right? It's on definitions, and the definition is supposed to be in respect of section 5 to 14, right? And then you get to section 15. It also from section 16 to 22, certain things have also been defined there. And then you later on go back to section 35, and then we also have interpretation. So meaning that in one legislation, we have about 3 interpretation sessions, so to speak. That's why the fact that the 2 other areas, they use the description definition by the same as interpretation. Let's look at the 15 then. For purposes of section 16 to 22, dependent in relation to a person whose death is caused by a wrongful act includes A, a member of the family of the deceased, and B, any other person who that member was by reason of adoption under the relevant law on adoption or otherwise obliged to maintain and who suffers loss or mental distress as a result of the death. So that is the meaning of dependent per section 15. So let's go through the answer. Which answers they do pick? Those who are there. Okay, so we put the provision. Okay, that is good. Thank you. So what is the answer then? Nobody made the choice. Okay, so C, I mean, that's quite obvious. Relatives and adopted children. Relatives and adopted children. That is quite tricky, but if you listen to the definition that we quoted, and then it's quite direct. A member of family of the deceased and any other person who by reason of adoption was. Okay, so relative adopted children, that is fine, but the relatives, that is the problem. So let us, because we have like the member of family of the deceased, right? And adopted children in C. So that one is more obvious and direct. B, children and surviving parents who rely on the disease. No, although you could say but this is a type of question where it is yes or no. The answer is that we just have to go for, because it's talking about definition of a word in a particular legislation. You know it or you don't know it, you don't have to guess. So that is the point that we have to note. Now, because we're in that legislation, let us take advantage. Let's take advantage of it and look at the meaning of the family, right? In the same section 15, it defines member of the family. What is the meaning of a member of a family? Member of family, according to section 15 of the Civil Liability Act 1963 at 176, means A, when used in relation to a citizen, any one of those whose person mentioned in the first schedule as a family based on the paternal or maternal system. B, when used in relation to a person who is not a citizen, the wife, husband, father, mother, grandfather, grandmother, stepfather, stepmother, son, daughter, grandson, granddaughter, stepson, stepdaughter, brother, sister, half brother or half sister. Okay, so let's say that things like this, you just have to look at them and then just be able to remember some of them. But more importantly, for those who are Ghanaians, the law has saved our customary law approach to family. So whether you are patrilineal or matrilineal, that will let us know who the member of the family is for purposes of the Civil Liability Act, particularly section 15. Okay, so let's move on. So when you are learning to, I also advise that just quickly run your eyes through the entire Act 176. It's not long. In the same way that you have to look at the Limitation of Actions Act, right? Limitation of action is also very important, especially the timelines. Simple contracts, when will it be considered as having been started bad? Action for title or recovery of possession, right? Just look at those things when you are revising. Emmanuel, Zaika, your hand is up or just by accident? Okay, you don't want to speak, all right, yes. Okay, 10, choose which of the following statement is not in accord with provision of the Criminal Offences Act 1929 on what constitutes intent to cause or contribute to cause an event. Okay, so we remember the Criminal Offences Act, and we know that in criminal law, to have a crime constituted, we have actus reus, that is a prohibited act, and then the mens rea, the requisite guilty mind for commission of that offense. And we have various types of mens rea, and intent is one way by which we determine that one had the prohibited or the requisite degree of mental state. So with respect to causing an event, certain indications have been provided in the Act 29. So there's a provision on it. So what provision governs that? This is what provision governs that? Section 11, okay. So can somebody read section 11 for us? Administrator. Okay, and then Jose. Yeah, can any of you read section 11 for us?
Section 11. of the Criminal Offences Act 1960. General explanations. Intent.
Yes.
Where a person does an act for the purpose of causing or contributing to cause an event, that person intends to cause that event within the meaning of this act, although in fact or in the belief of that person, or both in fact and also in the belief, the act is unlikely to cause or to contribute to cause the event.
Okay.
Then section 11(2). A person who does an act voluntarily, believing that it will probably cause or contribute to cause an event, intends to cause that event within the meaning of this act.
Are you done?
Although that person does not do that act for the purpose of causing or contributing to cause the event. It goes all the way to yes, all the way to subsection 6. I don't know
Okay.
if I should continue reading.
Okay, so we have Jose, are you the one reading, or is administrator?
I'm the one reading, sir.
Oh, right. Okay. Okay, you are tired of reading. Okay, my advice is that for the criminal law, even if you cannot read everything, there are certain essential things about criminal law you have to pay attention to. So first, about the substantive criminal law itself, let's say like the Act 29. You have to know like the general principles, right? Like some of these provisions that we are reading. You also have to know the inchoate offenses, right? Conspiracy, abetment, preparation, attempt, and so on. And then you have to know like the general principles which govern, like things like the dolus in capas and those kind of things, age of criminal responsibility and all that. These are basic things that we have to know. And then for the offenses, we have like the key offenses, like maybe like murder. You have to always revise your knowledge of murder, and then the manslaughter, dishonest offenses like especially like stealing, and sexual offenses. I know a lot of you have been asking me for material on the homosexuality. I've deliberately not come back to it. I'll do a one session on only that, probably before the weekend or something like that. We do that, so don't worry about it. Yes, Zaika, your hand is up.
Yes, Doc. Hello, Doc.
Yes, please.
Okay, I think since you just brought this issue, this criminal law thing subject came up, let me just suggest it so that you can maybe look at something and then put a question around it so that we can discuss around. Does this Kaswa murder thing that the small boy happened to kill the other small boy? One of the issues that they needed to determine before the trial would begin to ascertain the real age.
Right.
So if you could simulate a question around it, maybe.
Yeah, okay.
And then so that we can't look at it as like a minor case, and then we'll see how best we can.
Right. Okay. That is fine. Anyway, we can do that, and then also the Edra incident too. And okay, I mean that is fine. We can do something around that. Okay, thank you. So let's come back to question 10. So what is your answer? What did you put down? Grace, can you explain your answer? Why you think the answer is C? You can put up your hand and we allow you to speak. Let me, Grace. Okay. Grace. Is Grace still with us or she's sleeping? Oh, that was for question 9. Oh, okay, all right, okay. So what is the question to the answer to question 10? You can't see the rest of the option. Okay. Let me reduce that. Yeah. Yeah, so that's it. A person who does an act for purpose of causing or contributing to cause an event intends to cause that event, even though, in fact, or in his belief, or both in fact and also in that belief, the act is unlikely to cause or contribute to cause event. So that is in accord with the section 11 that Jules read for us. B, a person who does not intend to cause or contribute to causing an event, where notwithstanding what he may believe, his act is unlikely to cause or contribute to cause an event. Okay, so let's flag B as the one of the candidates for the right answer. So let's test that against the, because we look at the B, the person does not intend or cause, does not intend to cause or contribute to causing an event, where notwithstanding what he may believe, his act is unlikely to cause or contribute to cause an event. So let's give an example. Let's suppose that someone having like a toy gun actually pointed it to another person, and that person collapsed, seeing the gun pointed at him because he thought that he was going to be shot and things like that. So can we say that the person who pointed the toy gun, although as option B is suggesting, did not intend to cause or contribute to the collapse or death of the person? And can we say that the toy gun was unlikely to cause or contribute to the collapse or the death of the person? Certainly not. So let's go on to C. A person who does an act voluntarily, believing, who does an act voluntarily, believing it will probably cause or contribute to cause an event, intends to cause that event, although that person does not do the act. For the, yeah, of course, what they read, this was part of the what they read under section 11. So I think that C is cannot be the answer. D, there's a rebuttable presumption that a person intended to cause an event, where he does an act of a kind or in a manner that, if reasonable caution and observation have been used, it will appear to that person that the act will probably cause or contribute to cause the event. There will be great risk of the act causing or contributing to cause an event. Now, of course, C and D, they are all contemplated by section 11. So now we are left with B. And if we look at A, C, D, they are all contemplated by section 11. So the most likely answer will be B. Did anybody get any different answer apart from B? Okay, now let's go on to thought. Which of the following is not an intentional thought? Can anybody tell us what an intentional thought is? I'm not talking about the answer. What is an intentional thought, generally speaking? What is an intentional thought? Only 2 or 3 people are talking in this class. Are they the only ones who want to pass the exams? Okay. Since the intentional thought. And then Saint, your hand was up. Yeah, Saint, you can, Nana Jamfi, okay. Yes, explain intentional thought for us. Nana Jamfi and then Saint.
Hello, sir.
Yes, please, go ahead.
Okay. So I think intentional thought is one that can only result from the harm of the defendant. An example is battery or maybe assault. So you need to in order to find the defendant guilty, mens rea ought to be established in this case.
Nana Jamfi,
Yes, sir.
I disagree with your answer, but I'll take more responses and then I will explain. Why I
Okay, sir.
Okay, good.
All right.
Saint, okay, Davidson Jr. Davidson Jr., your hand is up. Yes, please. You have released, you can talk. Davidson. Davidson, I have released, you can talk. Davidson, are you with us? Or you raised your hand up in accident?
No, I'm talking, but it's like, hello.
Yes, we can hear you now.
Oh, okay. I was talking, but it's like you couldn't hear me.
Mike, all right, good.
So I'm saying that intentional thought, in my view, is more or less a trespass to the person. So that it's more direct, like, I don't know, but it has to do with a wrong that affects a person, like bodily harm, something of that kind. That's what comes into mind. Thank you.
All right, thank you. Okay, let's take Joss. Thank you. Joss?
Sir, I would have explained it as an act by the defendant which require proof of intention. For instance, false imprisonment. So where false imprisonment is alleged, there must be proof that the defendant actually intended to imprison the plaintiff against his will. So that is how I would have explained it.
Okay. All right. So you notice that, of course, this goes back to what you call the history of causes of action, the various forms of action. If you remember, where we have like the what do you call it, the vi et amis, right? And then they will have like the action on the case and things like that. That is where, so it has to do like the history of the forms of action, but intentional thoughts in a way is also a willful thought as opposed to negligence. A willful thought as opposed to negligence. And for that matter, yes, the other gentleman said that the first one, he said that you have to have like the mens rea. That's what I didn't feel comfortable, because like if you, of course, but the intentional thought or the willful thought means I must have a specific or general intent. But because we are accustomed to seeing mens rea in relation to criminal or criminal offense, that was why I was not too eager with the use of like the mens rea. But if he understands that in the sense of specific, that the fact that intentional thought should be committed with like a a specific intent, it should be like the, if you like the willful, as it were, then that is fine. But it is only of the historical significance when we highlight the various types of the action, where you have like, if you like the direct action, you have an action on the case, and so on. So the original action, that's why I said as a vi at amiss, that is by force of arms, right? So in the common law, the thinking of the common law was that every person, you have what they call their bodily integrity, and no one was supposed to invade the integrity of your person and things like that. So in the eyes of the common law, there was some kind of like enclosure around you. The same thing applies to land. That if you had your land, in the mind of the common law, there was like a fence around it, not like a physical fence, but the law sees some kind of like a fence around your land. And that is why, if you've not permitted someone to actually come onto it, then the person could be held liable for trespass, and it's on the same pedestal as what we call it, the vi at armis, that is by force of arms and violence. So which of the following is not intentional thought based upon what we have said? Let me look at your answers. Okay, one has said A, another has said B. Yeah, okay, Ernestina Dasa, I would like to hear you because I like your explanation. Ernestina, can we hear you? Ernestina, you can mute yourself. Ernestina, can mute yourself. Oh. You don't want to talk? All right, anyway, let's move on. So we have A, D. What are the response? Let me see. So I think the Ernestina, you made a nice point, and I wanted you to explain, because it reinforces the explanation that I was given, that the common law has a certain, okay, your network is bad. All right, that is fine, Ernestina, no problem. Yeah, like talking about the fact that intentional thought are actionable per se, there's no requirement of damage. I mean, that is fine. Okay, now let's come back to the answers. Some of you have opted for A, some have opted for D, right? Fraudulent breach of trust. Fraudulent breach of trust. Is it intentional thought? Isn't it a criminal offense? If we look at Act 29, section what? What provision govern the fraudulent breach of trust? Anybody? You go to the part of offenses involving fraud, dishonesty, and all that. What provision governs fraudulent breach of trust? Act 29, that is a Criminal Offences Act. I don't have my criminal offenses readily with me. So those who have, what provision governs that? If you have, yeah, can you read what provision governs fraudulent breach of trust? Is an offense in the Criminal Offences Act. Section 128. Yes. Can you read it for us? If you, yes. Asago. Asago. Asago is not, yeah. Asago, can you read the provision for us?
A moment, please. Hello.
Yes.
Section 128 of Act 29.
Yes.
Fraudulent breach of trust.
Yeah.
A person who commits a fraudulent breach of trust commits a second-degree felony.
Okay.
Then 129. Definition of fraudulent breach of trust.
Yep.
A person commits a fraudulent breach of trust if that person dishonestly appropriates a thing, the ownership of which is vested in that person as a trustee for or on behalf of another person.
Okay, good. So A is a criminal offense, right? We have what we call it a tort of deceit. We have a tort of deceit. A tort of deceit may have some aspect of a fraudulent breach of trust, but you don't need to have, if you like, the trust or the fiduciary relationship established before you can bring an action against somebody for a tort of deceit. And in fact, when we are talking about misrepresentation, right? Like fraudulent misrepresentation. Fraudulent misrepresentation you have in contract law vitiating factor is originally based upon an action known as the tort of deceit. The tort of deceit, yeah. So that takes care of that. But fraudulent breach of trust will not be treated as a intentional tort. Okay, assault. We know that assault is causing apprehension in someone. You put somebody in the state of being afraid that you are going to make unpermitted contact with his or her body or person. So if you like, somebody will say that this is an inchoate battery, that is uncompleted battery, in the sense that battery requires actual bodily contact, isn't it? And of course, that bodily contact, if it doesn't occur, and yet it introduces that fear, that apprehension in someone, that is the assault. And remember the case of Stevens and Myers, right? Stevens and Myers, Tuberville and Savage and all that. If you had not been for the sizes, I would not have taken this from you and things like that. Stevens and Myers at the meeting, the parish meeting, where the person attempted to deliver a blow, then it was intercepted from this. So malicious prosecution. Malicious prosecution has to do with where, yes, who will explain malicious prosecution? Queer.
Yeah.
Yes. Akuya, you have the floor. Akuya, you can speak. Oh, no, sorry. Yeah. It's Akuya there. Yeah.
Yeah.
Okay.
Hello.
Yeah, please go ahead.
The law on malicious prosecution, in the case of Musa and Limowolana, there were 5 elements stated in that case for one to establish the tort of malicious prosecution. So the very first element is that the plaintiff must establish that there was a criminal proceeding initiated which terminated in his favor, and then there was actual malice, and then due to that there was damage.
Okay.
So from my understanding, since malicious prosecution is an action on the case, there's no need for you to, you have to prove damage, yeah. So it's an action on the case.
Okay, so 4 elements. The fact that someone started a case against you and he did not have a reasonable and probable cause for starting the case. So there was a malice. That is a sinister motive, isn't it? And the case terminated in your favor. And so far as the case are terminated in your favor, you don't need to prove that you have suffered any damage. Okay? You don't need to prove, because so long as the elements are established, you instigated you brought a case against me, and usually has to do like the criminal case. Although there's a debate, especially in the context of the American restatement of the law of tort, as whether it can also be in respect of like the civil litigation, but by and large, it's really has to do like the criminal prosecution, that you triggered the criminal prosecution machinery, right, of the state against a person, and you did not have reasonable and probable cause, like a just cause and all that. Eventually, the case terminated in favor of the person, meaning that the person was acquitted and all that. So you have unnecessarily subjected him to the stress of trial, humiliation, and so on and so forth. If the person can show that, yes, when you initiated or you instigated or you triggered the criminal prosecution or the case against him, you had no reasonable and probable cause, you had malice, and then the case have also ended in your favor, meaning that your innocence has been confirmed or you've been acquitted. That is enough. It does not matter that you have actually suffered mental stress, you've suffered embarrassment. You don't need to prove that. So long as the elements are made out, you're entitled, you have a case against the person. Voluntary non-fit injuria means that the person that the consenting party cannot suffer a legal wrong. It is reasonable to conclude from this that, yes, I've seen the Salom.
Yes. Hi, Doc.
Yes, Salom.
What's the conclusion on the question 11, please? Because I'm a bit confused about the analysis of it.
That the fraudulent breach of trust is a criminal offense, and for that matter, if you use our elimination method, that is what will emerge as not example of intentional tort. But except that sometimes we see difficulty in how the questions are catched. And that is why last year we said it and we are saying it again. And then last year I did a joint class with the special prosecutor who was sworn in today. I'm trying to bring him again in one of the criminal law sessions. Let's hope that he gets the time. And the advice we gave was that the questions are not all the time perfect, right? The questions are not all the time perfect in the sense that you can debate the correctness or otherwise of the some of the questions or some of the options which are actually provided. Nevertheless, since it's an examination, it's not for us to determine whether the question is 100% accurately correct or not. So we go in for like the most suitable, right? The most suitable answer. And that is why we use that to settle on fraudulent breach of trust. Salom, but we'd like to take your explanation. Salom? Salom, are you there? Salom, yes, Barrister, I'll come to you, but I want to take Salom's explanation. Oh, Salom.
Yes.
Oh, yes.
I'm here now.
Yes, please.
I was a bit confused because we used the issue of fraudulent breach of trust being a criminal offense to sort of choose that, because in my head, assault is also a criminal offense, could be a criminal offense.
Right.
So yeah, it's just that's
right.
the part that's confusing me. Yeah.
Oh, right. I get your
But
point.
of course, I can understand what you're saying. When I see assault and battery, thought comes to mind. So
right.
Yeah.
Okay.
Thank you.
Pleasure. So let's take Barrister. Barrister.
Yeah, no, sorry, I was off. I didn't get the answer for the question 11. But apart from that, I have some clarification I want to make around the thought of malicious prosecution.
Right.
When I did my reading around, some of the principles I was getting was that on the issue of the fact that the defendant initiated the action, the initiation of the action, and then the other one, the termination in favor of plaintiff.
Right.
Those were the two when I read around the principle. I was finding it difficult to distinguish between at which point one will not be considered as merely performing his constitutional duties of perhaps in the case of the criminal.
Oh, right. There are a number of authorities, right?
Yes.
The number of authorities, I will try and pull some, like where, and that is why the elements, and in fact, the lady who spoke cited a local authority. What authority did she cite? Now that authority that she cited, the principles that the court has enunciated there, they're actually based upon the standard principles. So it's not very unique to us as Ghanaians. It's not the case that we have formulated our own elements of malicious prosecution. The principles have always been, right? And for example, if you even took like the, yes, Jos, you want to say something before I continue?
Yes, sir. In respect of that authority, Musa versus Limo Wulana, it actually included that the elements actually included that the plaintiff must show a proof of damage as a result of the prosecution. So, which may mean that it is not actionable per se.
Right. Yeah, so if I heard you, your point is that if the plaintiff cannot show that he suffered damage, he suffered injury, he suffered loss, then he cannot complain or he cannot bring an action in malicious prosecution. Is that your point? Is that your point, Josh? Hello, Josh. Are you with us? Josh, is that your point? I want to be clear on what you are trying to say. Oh, is it there? Or the internet is... Okay, so let's move on. I think we have to do one focus lecture on thought to cover some of these areas and also defamation. Yeah, I think, okay, good. I think George's line is a bit off, so let's continue with question 12. Voluntary non-faith injury means that a consenting party cannot suffer a legal wrong. It is reasonable to conclude from this. Remember, voluntary non-faith injury is one of the defenses to tort of negligence. We've also noticed that contributory negligence can also be a defense. So voluntary non-faith injury simply means that voluntary assumption of what? Of risk, where something is inherently risky and the person still decides to embark upon it or be part of it. Should anything go wrong, you could say that he or she was very much aware or to have known that that particular thing or situation was inherently risky, and yet he or she decided to take part. So let's look at some of the examples. It is reasonable to conclude from this that A, those spectators of games and sporting occasions accept the risk of injuries from the players, even when caused by intentional or reckless conduct. The first part, right? Okay, so we flag A. We haven't settled as the exact answer, but is a good candidate. B, a person who decides to travel on a vehicle of a driver who, to his knowledge, have been negligent before, accept the risk of an accident and its consequences. No, B is not a reasonable answer, because if someone had been negligent in driving before, it does not mean that for the rest of the person's life he has a license to be negligent in his driving. So if the person, for example, is not licensed or anything like that, that one is a different matter altogether. But once the person is licensed, if on one occasion was negligent, it doesn't mean that subsequently if you drive with him, it's like voluntary assumption of risk. I think that would be too much. So B is completely out. Those who own property adjoining the highway accept the risks of such accidents as occur without negligence. If your property is close to the highway, then it's like if an accident occurs, so long as there's no negligence, you cannot complain. See, but if there is no negligence, then the defense of voluntary non-faith injury does not come in, because the defense of voluntary non-faith injury is relevant where the elements of negligence are made out. But the tortfeasor is saying that despite the fact that I have brought myself within the elements, but the other party ought to have known that this particular thing was inherently risky and things like that. So if you are not talking, if the elements of negligence, for example, are not there, one did not owe a duty of care, and then the person's conduct or mission has actually occasioned breach of that duty of care, and there's a resultant injury. Why do you want to talk about voluntary non-faith injury? So let's look at the D. Nana Jamfi, is your hand up?
Yeah, yes, sir.
Okay.
I was trying to draw attention to what George said earlier on. He was trying to say that the malicious prosecution
Yes.
It's a thought actionable on the case.
Right.
So that's what he's trying to say. I think he didn't hear the lady's explanation well, so he thought she was saying that it was actionable per se.
Oh, right. Oh, right. All right. Thank you.
All right.
So D, a workman who works in a quarry where for months he sees stones swung by a crane over the heads of his fellow workmen and himself has accepted the risks of an accident from the fall of a stone, such as injured him. So what is the correct answer? Which of the following option best completes the above statement on voluntary non-fit injury? So now the question, you look at question 12, for example, how the examiner made it is confusing because the starting part, you like us to think that the question I just started from, it is reasonable to conclude from this that any of this. Then at the tail end of it, you are giving us another question task master. Which of the following options, A to D, best completes the above statement on voluntary non-fit injury? Okay, so the 4, and based upon the explanation that we have given, which of them would illustrate voluntary non-fit injury? Look at your answers. Okay, we have 2 competing answers. D and A. Okay, we have a lot of people saying D and one person saying A. So let's, of course, we'll be able to cross out B, that B is really, really unreasonable, isn't it? But B is saying that somebody have been negligent before, and for that matter, if you drive subsequently with him and anything goes wrong, like you should blame yourself because you ought to have known that he had previously been negligent. I mean, that is really, really unreasonable. So B is out. So we're using the elimination method to take B out has not been a good illustration of voluntary non-fit injury. Now, what about the C? Those who own property adjoining the highway accept the risk of such accident as with their negligence. Yeah, that is also unreasonable. You know why it's unreasonable? We do not know whether their property was there before the road extension and all that. So we don't have enough information for us to actually conclude on that. So that one, so B and C are out now. So now we have to juggle between A and D for the correct answer. Those spectators of games and sports occasions accept the risk of injuries from players, even caused by intentional or reckless conduct. Okay, so intentional or reckless conduct, all of them, despite the fact that the word intentional is used, they all have the effect of failing to exercise the duty of care, isn't it? So it will still come to the area of like the negligence, breach of duty of care, and so on. But let's compare that with the D. A workman who works in a quarry where for months he sees stones swung by a crane over the heads of his fellow workmen and himself has accepted the risk of an accident from the fall of stone, such as injured him. I think the D is not very reasonable. D is not very reasonable. And if you are to analyze it, D, in my view, then it will have the same analysis as how we analyze B, right? D will have the same analysis as how we analyze B. And for that matter, if you are doing the elimination, it will settle on the, what do you call it, that it will settle on A. You go to stadium to watch a football. You have to know that the ball, it can go off the pitch and get into the spectator where you are. And if it lands on you and breaks your spectacles, like my spectacles I'm wearing, it's a voluntary non-injury, because you have to know that it's a contact sport, is reasonably violent. You cannot contain, even a sophisticated sports stadium, you cannot contain the ball remaining there, isn't it? Or let's say that you go where they are playing tennis, right? They are playing tennis, you're a spectator. The ball can go off the pitch and then it can land on you. So that is a risk that you are taking. No matter how careful the organizers of the game are, they cannot give 100% arrangement, which can contain the possibility of the ball ever going out. That one is not possible. Yeah, so if you do the analysis, I think, yes, Davidson.
Sir, hello.
Yes.
Hello.
Yeah,
but sir, if you look at the caveat is given in A, where it's saying that even when it's intentional, so wouldn't
or let's say or reckless conduct.
But
it's intentional, but also reckless what conduct.
Yeah, but then it brings in intention here. I thought with volunteer, it's most of the time we look at it from the perspective of the one injured.
Yes.
The one injured. So I am injured because I allowed myself in a way to be injured. Not that the other person was bent on hurting me in any way, but I have sort of negligently allowed myself to be injured. But when it says that somebody with intent and recklessness even hurts me, and I am to accept it because I was there, I don't know. But then when you look at D is saying that for months you have been in a place where stones are being flown about. And then you being there for months, seeing stones dropped, such as one which hits you, isn't that acquiescence enough to say that you have assumed?
No, he said that the stones have been swung by a crane. It's not a natural, it's not a natural occurrence, though. The crane which is working in the quarry, isn't it?
Yes, but then when we look at the two circumstances, isn't that why in mining areas and all that, sometimes there's you normally have a clause or you bargain for these risk things. But for a spectator, if somebody was in, even because, okay, the long and short of it is that with A, why I disagree with A is because I don't know if you can throw more light on that. If someone is reckless and he intentionally hurts me, how is that my volition, or how have I contributed to his intentional thought?
Right. I get your point. I get your point, but let me listen to other people too. Okay, Davidson. Emmanuel.
Yeah, hello, Doc.
Yes.
I think I want to buttress his point, because if with the principles in the voluntary not fake injury is what is anything to go by.
Yes.
It's like you putting yourself in harm's way.
Yes.
And you know that when you go to the stadium or you go to be a spectator in a game,
yes,
the reasonable man will not expect the player to intentionally play the ball or use the ball to hit what do you call it, to hit the spectator.
Right.
Yes, but in the case of D, if you look at it, he's seen the what do you call it, he's seen the eminence of the harm.
Right.
The eminence of the harm is there. I mean, look at it, what do you call it, from the science background, you see that they tell you that efficiency is never 100%, even though it's a crane that is carrying, swinging the stones. But you know that it is possible that that machine can fail.
Right.
The stone can drop out of it.
Right.
And then so that is, you've seen the eminence of danger.
Right.
You see, that's where I'm also siding with them. I'm having a problem accepting or agreeing with the choice of A as the answer.
Okay, all right. All right, Emmanuel, I've heard you. Let's take Josh and me. And then, yes. Josh.
Doug, yes. So for me, Voleti, you look at it from the point of view that where you know that a particular risk would likely occur, and you assume the risk. Okay, that's how I'm looking at it. You know that there is a risk factor in here, you assume the risk. So maybe contrary to how my brothers see it, that is, if the way I look at it is contrary to how you see it, I would have gone with the A to say that where you know that a risk would likely occur, you nonetheless decide to assume that risk, then that will fall under the definition of volatile non-fit injuria.
Okay. All right. Okay. Thank you. Let me take a knee. After knee. Or is it knee who spoke? Knee, were you the one who just spoke? Knee Dodu. It's knee there.
Hello. Hello, Prof.
Knee, have
Hello,
you?
Doc.
Yeah, okay. You've not spoken yet. Okay, all right. Please go ahead.
When you look at the first point in the bottom line situation for non-fit voluntary non-fit injury is that it's a defense, and it is sometimes referred to this in this case as a risk that we've all agreed on the definition. But when you look at the case in the JC versus the state mining, you realize that to succeed in that defense, you must prove that the plaintiff voluntarily, with full knowledge of the risk, agreed. And that was what was decided in the JC versus the state mining. Then on the case of the D, answer the D that we are looking at. Though the rocks were being swung, but it is a vicarious liability in the sense that in that case, at least when you look at the ISA versus the main team-based issues, it will be seen that at the work site, this is even covered. So for me, I think that the answer that we are discussing should squarely fall on B, because like my previous colleague also spoke about, here the knowledge is there, and then the negligence before accepting the risk of that incident, that's and with consequences is also there. So that's my point. Looking at the two cases, that is JC versus State Mining Corporation, and then ISA versus the main team in the vicarious liability cases, to support those two issues.
Okay, thank you. I think that first of all, don't let us confuse. I'll come to St. Magri and then I'll come to Salom very soon. But don't let us confuse. Vicarious liability is a distinct principle on its own, and that is talking about where an employer is made liable for the torts committed by employee in the course of employment. So that is just about like transferring liability for tort to the employer. So that is a vicarious liability, and so that's a distinct matter. But let's take St. Mugai, and then we take Salom, and then I will draw your attention to something, and then we will end the class on this question. We'll continue tomorrow. Yeah, St. Mugai.
Yeah, voluntary non-fit injury is voluntary assumption of risk. So I was going to stick with the A until the last portion came in, even when it was done recklessly. So I think that negated the first description of what constitutes voluntary non-fit injury. Because in sporting events, for example, this contact sports that you made mention of, if you hit the ball against, let's say, the referee has voluntarily assumed that risk. But when it is seen clearly that you intentionally hit the ball against the referee, I think you can be sanctioned. So the first bit is correct until the last bit came in. That made me confused a bit. Thank you.
Okay, all right, thank you. Now let me take Salom. Yeah, Salom.
Yes, hi. Yes, Doc, I would agree with what the initial speakers have said. I just, if I'm permitted, if I could read, I went to one of the books I'm using, and it spoke specifically on sporting events and how that and voluntary sort of how we reconcile that. I don't know if I'll be permitted or if I should just type it.
Go ahead.
Okay, so let me read the relevant portions. Okay, so it says a spectator may be taken to have accepted those risks ordinarily incident to the game. For example, being hit by a cricket ball stuck to the ground. But in the case where there is no negligence, voluntary is irrelevant. The potential liability of the participants depends upon the standard and scope of duty of the care owed. And in Woodridge versus Sumner, it was expressed by Diplock as a duty not to act with reckless disregard for the spectator's safety. So I also had that initial thoughts, like the just ended speaker said, until the last bit where it spoke about it being reckless, the act being intentional and being reckless. In that case, but what I've read and even your own discussions, and it appears that where there's no negligence, we can't rely on volunteer to sort of as a defense for the defendant. So that's what I'm also thinking. I'm sort of agreeing that it shouldn't be A.
All right. Davidson, is your hand still up or just the first one?
It's a mistake.
Oh, right. Okay. Okay, before we end, let's maybe focus on one or two things, and then we'll settle on the A and the D conundrum. He said that from the players, even when caused by intentional or reckless conduct. So let's suppose that a football or anything, and the reckless conduct here is not talking about the fact that only directed at the spectator, right? So let's suppose that a player trying to play very rough decide to give a strong shot targeting the ball at another player, and instead of hitting that player, it goes off to hit a spectator. Will it be any different? Will it be any different? Because my question, right? My question is that if you analyze option B, you analyze option D. Yeah, so let's say like the B, a person who decided to travel in a vehicle who, to his knowledge, have been negligent before, accept the risk of an accident, and this one's okay, we've ruled that out, that is fine. Because we said that if somebody has been negligent today, he doesn't have a license to be negligent tomorrow. Yes, Salom, your hand is up.
Sorry, I think it was from, sorry, I don't think.
No problem, okay. Yeah, so B is out, but let's say A, what is causing the problem for us is the use of the qualifier that even when caused by intentional or reckless conduct. And a bit of confusion there is that the intentional or the reckless conduct, is it referring to the injury caused direct, like let's say intentionally, like hitting the spectator with the ball or whatever the game involves, or is talking about where the particular player, as a result of intentional rough play, has occasioned an injury to a spectator. I think that is what had been probably be confusing those who opted for the A. Now we come back to C. As we indicated, those who own property adjoining the highway accept the risk of such accidents without negligence. So let's say that if you're on like the motorway, right? Your property is just by the motorway and a car runs up the road into your house. Can the owner of the vehicle, once you for negligence, say that, well, by putting your house there, that is you ought to have known that there's a high risk that accidents and all that, and if something has gone wrong there, then you voluntarily assume that. Can we actually say that? Well, I made the point that it is difficult in terms of logic for you to make that argument. Then what about D? We have like a mining area or a sign winning area where a pin is known to have swung a stone over the head of some workers himself. The person still continued to work there, knowing that this incident has occurred before. So if something goes wrong, he should not be allowed to complain of negligence, because aware of what has happened there before and all that, he should be taken to have consented to the injury. Yeah, that is, I still have, I'm not convinced by the D, but I see the confusion in the A. So I would like us to end inconclusive as whether D is the correct one or A is the correct one. And I'd like all of you to go read more about voluntary non-faith injury. And when we meet next time, we use the first 5 to 6 minutes to settle the debate. So on that note, I would like to wish you a good night, and we'll continue later.